So good morning, everybody. I am Alessandra Di Martino, Professor of Comparative Public Law at Sapienza University in Rome and co-editor of Diritti Comparati, our blog and journal about comparative law. I am very pleased to welcome Professor Grimm, emeritus from Humboldt University and fellow and former rector of the Wissenschaftskolleg in Berlin. Professor Grimm has a lengthy career as a constitutional lawyer. He taught constitutional law in Bielefeld and Berlin. He obtained an LLM from Harvard University, was visiting professor at Yale and in many universities worldwide. He holds several honorary degrees and is member of several prestigious academies. He was a member of the German Constitutional Court. His work gained the attention of a wide international audience. He has written extensively on constitutionalism and constitutional theory within and beyond the state, constitutional history, fundamental rights, constitutional adjudication, addressing all these subjects with a particular sensitivity for comparative law. His latest book, published in 2022, is about the German historians and the Constitution. I would like to begin by asking you about your early career, which I believe is significant for a comparative lawyer. I was very interested to find out that your initial research was centered around legal history and French law, which you also deal with in your Habilitationsschrift about constitution and private law in the 19th century, published a few years ago. I also believe that your period in the US at a time which was quite unusual for German scholars was important. Could you tell us something more about this?
This dates back already to school times. I was very much interested in foreign languages. I liked foreign languages. And in our school at that time, there was a particular emphasis on French-German relations. Was of course after the war and after a long period where France and Germany were enemies. So for me it was quite clear that I would like to go abroad during my study of law or after my study of law. And it's happened that I went to France after I got my German law degree. That was in 1962. And I spent a year in the Faculté de Droit in Paris. I had deliberately chosen a topic for my doctoral dissertation that was related to France, namely the theories of an eminent French legal scholar of the first half of the 20th century, Léon Duguy. So with this subject, I went to Paris, but I went to courses. I must say, however, that studying constitutional law in France was not very promising. There was no course on French constitutional law. There was a course Institution Politique. There was nothing about fundamental rights. So I would say from a scholarly point of view, the Paris time was not very important in other respects. Well, because it is a fabulous city, and I enjoyed that very much. So I then started my practical training that is mandatory for every German jurist and ends with a second exam. And I interrupted that in order to go to Harvard. It was my idea that I need some insights into a different legal system, namely the common law system. And there, of course, at Harvard in the United States, constitutional law played a big role, and I wrote a paper in order to get my LLM degree on the influence of natural law on the formation of the American Constitution. And then my first position in my career was a position at the Max Planck Institute for European Legal History. European legal history, that's to say, that was from the very beginning a comparative venture, not in actual law, but in past law, former law, but anyway, it was comparative. So it runs really through my legal education at the beginning of my career.
Thank you. I would now like to delve deeper into your methodology in constitutional law. As far as I know, you did not belong to either of the two biggest and most traditional schools in German constitutional law, Schmittian and Znendian. Nevertheless, or perhaps because of that, you developed an original theory, which considers the Constitution and constitutionalism mainly as the outcome of an historical development. You maintain that the Constitution fulfills certain functions, constraining political power, but also integration, consensus building, and conflict relief, and is subject to sociological transformations and challenges. My first question is, what is the relation between historicity, functionalism, and normativity in your thought? And secondly, how do you reply to those who see in this development a history of state decline, Verfallsgeschichte in German?
Yeah, I think you describe my approach quite correctly. I'm convinced that one can understand law, legal provisions, codifications, legal institutions, only if one knows the conditions under which they emerged. Law is always enacted with a certain purpose in mind. It shall fulfill a certain function in social reality, and either function to preserve the current status of social reality or in order to change it. It both is possible. But this relation with the segment of social reality to which the law applies has to be taken into account because it is an element that explains the meaning of the law. Now, of course, social reality is in constant change. And this means that if you stick to the original interpretation of a legal provision, but the field of application, the segment of social reality has changed, it may happen that you either miss the purpose of the law or you reach dysfunctional results. So I think that in order to be faithful to the purpose or to the function of a legal provision, it may be necessary that you have to find a different interpretation, of course, within the limits that the text of the law draws. And I think this is my approach, has been my approach also in the Constitutional Court, that I need the historical dimension and I need the social science dimension in order to be able to not only to develop a full understanding of the law, but also to adapt it to changing situations, to make it relevant in the practice of law.
Thank you very much.
The second question about the state, is that right? Yeah.
The history of decline, Verfallsgeschichte.
Yeah. I mean, what I see happening is that that the state is losing importance. It loses importance because the problems that can be solved within the limits of the nation state diminishes. We see ever more problems evolving. That can only be solved on the international level. And this is why a number of international organizations have developed, and these organizations distinguish themselves from earlier alliances or organizations, that they exercise public power. The states have transferred public power to these organizations, and to the same extent the state loses relevance, and to the same extent the constitution of the state loses relevance because its field of application is narrowed. With every transfer of a power to an international organization, the constitution, the national constitution, loses. On the other hand, I wouldn't say that the state is already obsolete. It is an important entity, more important than the international organizations are. In democratic terms, it's almost impossible to replace it, so we need it for quite a while, I think. But that there is a diminution is clear. Now, for me, it's important to say I don't deplore that. I don't say how sad that the state is no longer what it used to be for a number of decades. I just state the changes, I analytically state the changes in order to be able to see how we deal with the new situation. And one of my most important questions, of course, is how can I elevate what I call the achievement of constitutionalism? How can I elevate, or can I elevate it, and to what extent can I elevate it to the public power that is exercised on the international level?
Which brings us to the next question, which is about the challenge of supranational integration and European constitutionalism. Your renowned thesis is that European treaties and law have gone through a process of over-constitutionalization without this being supported by a sufficient democratic legitimacy. In the light of your demanding concept of constitutionalism, you hold that the European Union does not have a real and proper constitution. You do not exclude that this could change in the future with the institution of a European Federation, which presupposes at least a more integrated public space and party system in Europe. In this respect, your position is close to the jurisprudence of the German Constitutional Court from Lisbon to PSPP judgments. One of the main objections to your thesis is that it is too rigid, with a strong conceptual opposition between international treaty on the one hand and constitution and constituent power on the other, a view which would seem to take as its yardstick more the French than the American model of the Constitution. It also seems to underestimate other federal constitutional experiences and the historicity of contemporary forms of power in supranational global arenas. And yet, one strong point in favor of your position is a more sober realism. Can you elaborate more on that?
I like the last sentence. I realize, of course, that there are many forms of constitutions or constitutionalism. There are strong and weak forms of constitutionalism, thick or thin forms, if you like. And in order to have a benchmark to evaluate various constitutions and also what is happening on the European scene, I try to find an expression, and I call it, I mentioned it already in my last answer, the achievement of constitutionalism. The achievement of constitutionalism, under which I understand that that every public power needs a basis in the Constitution, to say an authorization, and that the exercise of public power can only happen in accordance with law. So every act of public power in a certain territory must be based on and exercised within the constitutional realm. This is what I understand by the achievement of constitutionalism. And this presupposes, of course, that the Constitution enjoys a supremacy. And it presupposes, in my view as well, that the source of the Constitution is the people or the society. It's not necessarily people. I say that because very often people criticize me by saying that I have an idea of the necessity of a people in order to have democracy. This is not what I think, but you have a society that can have a discourse on political matters in one language or in more languages. But so a source in the society or in the people, and this because every other principle of legitimation of public power weakens the Constitution, because when it comes to a conflict with the other legitimation of power, be it religious, be it secular, then usually the Constitution will lose. So this is the achievement. And I insist on that when I speak of achievement, it's not an ideal. It is a legal reality. We have countries where that exists. Now comes the European Union. And with the European Union, a lot of powers have been transferred from the national level to the European level. And the consequence, of course, is that the Constitution is no longer in a position to fulfill this claim. Every act of public authority within a certain territory has to be based on the Constitution. This is no longer this is no longer possible. Now, you say I'm speaking of over-constitutionalization of Europe. Over-constitutionalization, of course, presupposes in the first place that there is a constitutionalization. And this is a fact that characterizes the European Union, a fact that was first discovered not by Europeans but by Americans, Eric Stein in Michigan and Joe Weiler in Michigan, who found out that the two famous and extremely important judgments of the European Court of Justice of 1963 and 1964 had the effect that they constitutionalized the treaties. This is not to say that the treaties all of a sudden became a constitution in the normal sense, but it means that the treaties were endowed with the effect of a constitution, and the effect is that it had primacy, it has supremacy over all other legal acts. That's to say, it functions now in various respects like a constitution. But in my view, given the achievement, in my view, it's still distinctive of a constitution because the democratic element is missing. The European treaties that function like a constitution, I could call them a functional constitution, I wouldn't mind to do that. These don't have the democratic background. It is the states who have made the treaties, and it's the states, only the states, the member states, that can change the treaties. So this is the reason, but now comes an important point. The effect of constitutions is, of course, that everything that has been regulated on the constitutional level is withdrawn from politics. There, the democratic process has no room. This is why we have constitutions for. We would like to distract certain things from the democratic discourse. For instance, the rules of the game. In the European Union, the treaties were not meant as a constitution when they were written. The member states were not aware that they would write a constitution. So if we compare the treaties to constitutions on the national side, we see that national constitutions, just because of this democracy-reducing effect, confine themselves to some principles, organizational, procedural principles, and some subjective, material principles. So they regulate the process of political decision-making, but they don't take the decisions themselves. This is a matter for the democratic process and for ordinary law. And when we look to the treaties of the European Union, that we see that they are full of ordinary law. They are full of what would be, in all member states, would be ordinary law. And that means, of course, it can at any time politically be changed. All this ordinary law that is on constitutional level in the EU cannot be changed in the ordinary democratic process, only by a treaty amendment. And this power that normally is with the democratic process accrues now with the judiciary. This is why the European Court of Justice is so important. It immunizes itself against being corrected because everything that it decides is on constitutional level. And here I see the most important democracy problem of the European Union. Not that the parliament is not strong enough, as many people think, but here is the place where one should change things if one would like to democratize the European Union more.
Thank you. My next question is about constitutional adjudication. Contrary to many contemporary critics in Europe and especially in the United States, you defend constitutional adjudication in general and the German Constitutional Court in particular, perhaps also because you were a member of the court. As to the most sensitive problem, the allegation that constitutional courts or courts with constitutional jurisdiction play politics while not having a democratic legitimacy, you stress that a way out of the dilemma is to consider the specific rationalization of the legal method and doctrine. Could you explain this point and make a comparison between the German Constitutional Court and the US Supreme Court? And I would also like to ask you how your activity as constitutional judge influenced your view on this.
Mm-hmm. Yeah, I think I formed my general ideas about judicial review and constitutional adjudication before I became a member of that court, before I could even think of ever becoming a member of that court. And I saw early, rather early in my career, already quite clearly the benefits and the risks of judicial review. The benefits are obvious, I think, if we compare political systems, either in history or currently, with constitutional review and without constitutional review. We can see that without a few happy countries, in countries without constitutional review, the relevance of the constitution is small. It's not nothing, but it's small. Normally, politics operate in the organizational framework of the constitution, but when it comes to the exercise of public power, constitutions are not very relevant. We can see that for almost 150 years of constitutionalism, fundamental rights were without legal relevance, with the exception of that country that had judicial review, namely the United States. Now, the risks, of course, are that decisions of a considerable political weight are taken not in a political mode, but in a juridical process. That's to say, by people who have a democratic mandate because they have been elected or appointed by elect persons, but they are not responsible. They are not accountable vis-à-vis their society, what they do. And this is the risk that important political decisions are decided in a non-political mode, and it's difficult to correct them if one is not doesn't like them. So this is the constellation, and we can observe that in various countries the accommodation or the evaluation, what is bigger, the risk or the benefits, is different. And I see that in particular with regard to the United States. The United States, there is certainly a much bigger awareness of the risks of constitutional review than it is like in Europe and especially in Germany. And I trace that back to the fact that in the United States there was democracy before there was judicial review, whereas in Germany and other countries, Italy, same situation. The judicial review came after a democracy had failed. So it's very much understood in our countries as a safeguard of democracy, and the risk aspect of democracy is more in the background than in the United States or the Anglo-Saxon world. And then you are right with what you say. I'm not prepared to join the American attitude that it would better either to give up constitutional review or to reduce it significantly, or to make decisions of the court, in the American case of the Supreme Court, not binding, so that it can be overruled by Parliament. This is not my idea, but my idea, as a matter of fact, is, as you say, that one should not underestimate the rationalizing effect of legal interpretation if it is done in a correct way, inspired by a legal method. I would not go as far as to say that interpretation can be, so to say, completely legalized. That's to say that there is no rest where, how should I say, personal convictions, socialization of judges may have an influence. This is inevitable, but one can reduce it. I think one can reduce it with doctrine and with methodology to a quite important extent. And so for me, it's easier to justify judicial review than for an American.
Thank you. My next question is about fundamental rights, a field where legal doctrine in Germany is particularly refined. You are a defender of the so-called objective dimension of rights, obligation to protect, horizontal effect, etc., and of the proportionality principle, but your justification does not draw from the order of values, Wertordnung argument. Here again, your position cuts across traditional schools and is widely followed in constitutional practice. My question is raised from an Italian perspective, since the Italian constitution contains a strong substantive equality principle and a wide social rights protection. In Germany, how is the objective dimension of fundamental rights related to the welfare state? And does the tension between the rule of law, Rechtsstaat, and the social state, Sozialstaat, still play a central role in German constitutionalism?
Perhaps before I answer your question, I would like to say that I'm not opposed to the value approach to fundamental rights, but I make a difference. The normal language in Germany is fundamental rights are values. I insist on saying that fundamental rights are legal expressions of values. I think this is an important difference, because you cannot right away, in order to interpret fundamental rights, go into the heaven of values and from there determine the meaning. It has to be a legal process to determining the meaning. But now the question that you ask, I think that the objective dimension of fundamental rights fills to a certain extent the gap that exists in the German constitution compared to the Italian with regard to social and economic rights. Deliberately, the Weimar Constitution had abundantly social and economic rights, and the decision in the Parliamentary Council of 1948-49 that drafted the constitution was we would not like to have social and economic rights. They were not opposed to that. There was a strong social democratic. Half of the members of the Parliamentary Council were social democrats, but the reason was more, we do not know how Germany develops. Will we at all be able, in this period of time, after the lost war, after the destruction of the country, after the industry being modern, will we be at all able to fulfill social and economic demands? So the objective dimension, I think, fills a number of gaps. Dignity, from dignity we derive the right of everybody, not only Germans, everybody to the existential minimum. And dignity is understood as an absolute right, so you cannot limit that. You cannot say, well, I give to foreigners existential minimum minus. That wouldn't be possible, for instance. Then we include, as a consequence of the objective function, we include into fundamental rights the idea that the preconditions to make use of a right are also guaranteed. To what extent is a different question, but you should not have an empty right that is useful only for people who are wealthy and rich, but you should have also the preconditions of using the right. Now, we haven't seen a situation where this became a real issue, because I would say that still the social security legislation in Germany is on a rather high level. So that it was not really necessary to say, is a reduction, a significant reduction of social and economic welfare benefits compatible with fundamental rights or not. We haven't had this. We have had cases, but they didn't present a real problem. That could, of course, change if it becomes more difficult to hand benefits over to those who are needy. The last part of your question, the answer is easy for me. This old discussion about a contradiction between rule of law and the social state does no longer exist. It was something for the early years, and it was something for a methodological school that thought that everything that is not just limiting government should not be on constitutional level. But this is over.
Thank you. My last question concerns your latest book. You maintain that general histories of the Federal Republic of Germany do not take constitutional history enough into account, and that understanding the relevance of some constitutional acts or interpretations would have led to a different understanding of history. Could you give a couple of examples? And relating to your premise that the German Basic Law was a success story, I wonder whether there were perhaps some less successful moments. For instance, 2 interesting chapters of the book deal with the reunification, an issue which has just recently and lively resurfaced in the German public sphere. Could you illustrate which alternatives there were to the easier extension of the basic law to Eastern states back then?
When I speak of a success story, I understand that as a general statement for the development of almost 75 years. Next year, there will be an anniversary. The basic law will be 75 years of age. So it's an overall statement, and it doesn't mean that everything that happened in the constitutional world at that time was a success story. There were differences. It's not a linear success story from 1949 or 51, when the Constitutional Court started its work, to the present. But indeed, I would say I see more success than failure. I think that that no German constitution ever had such a degree of relevance for political behavior and also for the social conditions of people who live in Germany. And of course, through the jurisprudence of the Constitutional Court. Without the Constitutional Court, this would not have been the case. And here I think an important distinction between Italy and Germany comes in. The German Constitutional Court has much more opportunities to rule on all sorts of problems, social problems, societal problems, not only legal problems, because it has the individual complaint, which is not present in Italy. The German Constitutional Court has meanwhile around 6,000 cases per year, and 98% plus minus of these cases are individual complaints. And so very important questions and very important judgments of the Constitutional Court were answers to individual complaints. That's to say, a procedural way that wouldn't be open in Italy. Now, furthermore, no German constitution has enjoyed such a support and such a degree of acceptance in the population. And I would say that is even true after unification, although the acceptance in East Germany is lower, but not significantly lower than in West Germany. And finally, the international influence. In the second half of the 20th century, when new constitutions were made, when states turned from dictatorships to liberal democracies, very often the basic law was a model, and certainly the Constitutional Court was a model. And I realized that I was during that time a member of the German Constitutional Court, and delegation after delegation from these new democracies came to discuss with us about constitutional review. So these, I think, are the important and good sides. And if you ask for examples, I would just mention 2 things. The development of fundamental rights is just amazing in that period. What became of fundamental rights that were originally only conceived of as limitations to government action, they expanded through the objective dimension. And certainly the Constitutional Court, I think, in the early years was ahead in its liberal attitude, ahead from the population. Freedom of speech, freedom of art, freedom of demonstrations were areas that really could develop because of the jurisprudence. The ordinary courts in Germany, criminal courts, administrative courts, civil courts, were on a much lower level. And the other thing that I mentioned is the attempt of the court to keep the political process open. Of course, political parties are always inclined to use their financial or political means when they are in the organs of the state to enhance their own chances in the next election. and to diminish the chances of the competitors. And this was the case in Germany abundantly over and over again, and the Constitutional Court usually stopped political parties from doing that. But now, of course, not every judgment is, in my view, a success. There are judgments that, in my view, are wrong. There are even judgments of which I say they are embarrassing. I think of a judgment where the court explained in length why male homosexuality can be punished, but female homosexuality cannot be punished. And it based this decision on explanations in which sense men and women differ from each other. It's really shaming when you read that. And there are other cases where I would say this is not what I would have decided had I been in the position at that time. And of course, I was not always in the majority during my 12 years in the court as well. And what I should add in addition is the court was not, it's not so that the court was never in danger. There were tricky situations for the Constitutional Court. Immediately after the Constitutional Court had been founded, it was in the first year already, drawn into the tremendous political questions of Western integration and rearmament of Germany. And the court didn't decide it as the government wished that it had decided. And Adenauer, Chancellor of that time, said this. He was at the same time the president of the Parliamentary Council that drafted the Constitution. And he said, this is not what we had in mind when we established the Constitutional Court. And he tried to get his hand on the Constitutional Court. That failed because the opposition and the Länder were firmly in favor of the Constitutional Court. Then we had a period after a long time of reign of the Christian Democrats in Germany, the first social liberal coalition under Willy Brandt, with an enormous reform program. And many of these reforms failed in the constitutional, or many is an exaggeration, but substantial reforms failed in the Constitutional Court. And now the danger didn't come from the government, of course, but it came from the government, but in addition, it came out of society. Society in the first crisis were more or less behind the Constitutional Court. In this case, the court was perceived as a threat to democracy. There is a new majority, and this new majority cannot implement its program with which it won the election. And then again, there was a crisis in the years, and I was there 94, 95, when the court rendered a few decisions that found the society, that surprised society, not only surprised, but it enraged society. There was tremendous protest. But it was a matter of a number of months until the court was again on its old level of acceptance.
So that brings our interview to a close. Thank you very much, Professor Grimm, for speaking with us.
Thank you.